Now, looking at just the text of the provision, there are two possible constructions of clause D. Constitutional practice may seem to support what Mr. Sibbal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
other than 1 and 2.
Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of concurrence of the state. All right? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is that even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence, even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
That's correct.
Now, the question is really which is a more plausible construction?
Actually, if your Lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibbal, the Chief Justice, that constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire Constitution has been adopted in terms of clause D. If you require modification or changes in that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render 3 OCOs completely. C will become OCOs.
C is
the provisions of the Constitution.
The C is something different. C dilutes the article itself.
C, I am not on anything else. When you see other provisions of the Constitution, except for 1 and the 370, you can't touch 370. But let's move forward, Madad. I'll be able to show that to your lords.
P is 370 and C is Article 1.
And 1 is Madad integration. So that can't be touched. Part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched. C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. Doesn't say it's done.
By now, your lordships have, in fact, may I tell your lordship something interesting? Because I looked at the original Constitution of India. Learned friend will show it to your lordship. It was only a marginal note. It's not the heading of 370.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your lordships have held in Keshavanam Bharti itself. Can't look at these notes.
No, in the sense that a marginal note doesn't control the meaning of the text.
C and 3, Article 3. You can't. A marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done. Anyway, come to that one. Let me show you. It's very fascinating.
Yes.
But take a bit of time. Let's kindly come to 370 presidential order.
Yes. That 1954 order.
1950.
Let's have a look.
Same volumes.
1950 or 54?
No, Malas, I'm coming to 50, Malas. Liquid text. Volume 3. PDS paid 4 months.
This is what you were reading as 13. No,
that is the 54 order. I'm coming back to 1950 order, which was superseded by the 54 order.
This is where?
This is PDF 4 in the same volume. The other was on at 13. This is at 4.
So at 4.
Okay. Yes.
Are you referring to CO number 10, Mr. Sibbal?
Yes, absolutely. Well, let's kindly see the index of this. 3 pages earlier. Yes. See what has happened here. This will give you the kind of orders that have been passed from time to time. There are, by this time, about 54 orders. These are probably not all the orders either.
Very first page of the volume.
Yes, yes.
The first page of the volume.
That's right.
You're looking at
There's
the
a whole
different
index of all the orders.
orders issued.
Yes.
Serial number 1 was superseded by serial number 5.
To specify.
Now read it with me. The order may be called the Constitution Application to Jammu Kashmir Order 50, which should come into force for the purposes of subclause B1 of clause 1 of Article 370 of the Constitution. The matters specified in the first schedule to this order, being matters in the union list. This is in consultation. Kindly read the words. In exercise of the power of 370, in consultation with the government of the state. For the purposes of B1 of clause 1 of 370, the matters specified in the first schedule to this order, being matters in the union list, are hereby declared to correspond to matters specified in the instrument of accession, governing the accession of the state of Jammu Kashmir to the Dominion of India as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for that state shall be limited to matters specified, which your Lordship said is the limitation. Rightly said. Now come. In addition to the provisions of Article 1 and 370, again, of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to this order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and the modification of that all references to the said provisions shall be construed as reference to the Sadre. This is applicable to D. First schedule deals with entries, and this deals with D, because you're not to apply now the provisions of the Constitution of India, and they are all incorporated in the Constitution of India as applicable to Jammu and Kashmir order. So 356 also comes there, Part 3 comes there, Preamble comes there, Directive Principles of Policy come there, but that's all with concurrence. Therefore, it didn't come at this stage. That happened later. Then you went, then now kindly see the first schedule you have seen. These are those very entries that we were talking about. And kindly see the second schedule. It starts, at PDF 6, page 17. I just for my Lord. PDF 6, page 17. Kindly see exceptions. Article 72(1), provisions of the Constitution applicable. So there was no doubt on this issue, Madam. Entirety of Part 5. But in Part 5, 72(1)(c), 72(3), 133, 134, those are exceptions. Last column is modification. So it's not just a question of application. It's a question of substantive understanding of what 370 is. Even if you want to apply a provision without modification, you need consultation with respect to or concurrence. You can't. There is no third way of doing it. Yeah, that's excluded anyway. I said that we've given the examples. Modifications 54 and 50 shall apply subject to modifications that the reference therein to the elected members of the Houses of Parliament to each elected member of either House of Parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. So you modify. 54 and 55. Then if 247 you modify. 246 shall apply subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply. So you can't pass a law.
So what is the effect of clause 2 and 3 of article 246 not applying in relation to the state?
Because the residuary power is with the state.
No, but 246(2) says, refers to the power of parliament and the state to enact laws on the concurrent list.
That's fine.
No, but if 2 is not applicable, then neither the state nor the parliament can enact a law on the concurrent list. then.
It is because of 1B, Malad. It only tells you the methodology, Malad, that's all. The point is, what my lord is putting to me is, the president can exercise powers under 370, dehors a modification. That's an exercise of plenary power. That's what my lord is putting to me. But Malad, this clearly shows that even that exercise has to be done with concurrence. If it relates to the concurrent list and consultation if it relates to instrument of accession, can't be done any other way. So it's not a matter of practice alone, it's the substantive interpretation of 370.